Welcome to Rebel Chaser. My name is Gail, and this is part 4 of the daycare worker trial in Tennessee with Judge Wolf. And the defendant is actually going to speak. She's going to testify. So you get to watch that. That's kind of a big deal. That's the biggest deal for the day. And then the verdict. The verdict is going to be a separate video though. So this is all the way up until they do the verdict, and then the verdict will be number 5. So I'll let you guys watch.
Anything we need to address before we bring the jury out?
No, Your Honor.
All right, then let's bring the jury out. Good morning again, ladies and gentlemen. Just so that the record is clear, does anybody have any issues, anything that's arisen since we were last together that we need to address? All right. Then we are still continuing with the defendant's proof. So, Mr. Stryans, if you wish to put on any other witnesses.
Yes, Your Honor. Defense calls Sarah Jo Fuson.
Right.
This is on, right?
Good morning, Ms. Fuson.
Good morning.
If you would state your name for the court, please.
My name is Sarah Jo Fuson.
And how old are you today, Ms. Fuson?
I am 25 years old.
And tell the jury, where do you live?
I live in Woodlawn, Tennessee.
Where is Woodlawn?
It is the west side of Clarksville, Tennessee.
And how long have you lived in Woodlawn, Tennessee?
Since birth.
And who do you currently live with in Woodlawn?
My mom, my dad, and my brother.
And do you also have a sister?
Yes.
And where does your sister live?
She lives on base.
And when you say on base, tell the jury a little bit more about that.
On the military base, Fort Campbell.
And does she have a young child?
She does.
And tell us a little bit about that. What's her?
Her name is Willow Cole. She is my absolute world. I do a lot with her. She loves to ride in the car with me. When she stays the night at our house, she sleeps with me. I take her to do activities, like take her to the park or the jump park. We just do a lot together, and she's constantly asking her mom for me to stay the night.
And how old is Willow?
Willow is 5.
And what does your mom do?
My mom is a school teacher.
And what does your father do?
My dad is in law enforcement.
Tell the jury, how far did you go in school?
I obtained an associate's degree in liberal arts from Austin Peay State University.
And do you remember when you received that degree?
So I received it in 2020, but I wasn't able to walk until May of 2021.
Was that because of COVID or?
Correct.
Okay. Let's talk a little bit about your work history. Did you work in high school?
I did.
Tell the jury what kind of jobs you had in high school.
I worked at White Castle, and towards the end of my time at White Castle, I was a crew trainer.
How about college? Did you work when you were in college?
I did.
And what kind of jobs did you have when you were a college student?
I worked at Panera Bread for a little bit, and then I worked at Kohl's in customer service for 2 years. And then I worked at a vet.
Okay. Now, after you received your associate's degree, I think you said in 2021, what kind of work did you do?
Right after that was the vet clinic.
Did you have any other jobs?
I did babysitting a little bit.
Okay.
And I think that was really it.
Did there come a point in time that you worked at a daycare called Golden Apple?
Correct.
When was that?
That was April of 2022, I believe.
And what was your job at Golden Apple?
I was an assistant 2-year-old teacher.
And where is Golden Apple located?
Golden Apple is located near the DMV. I can't remember which road though.
And I may have asked this, but how long did you work at Golden Apple?
I worked there from April to July.
And what drew you to be interested in getting a child care job?
I've always loved kids. I've always cared for kids. I've cared for kids since I was about 15 or 16 years old. And kids just bring me joy. When I was at Tylertown, I absolutely loved all the babies that I worked with. They were my whole world. And I love kids. They bring me a lot of joy.
Let's talk about Tylertown. When did you go to work at Tylertown Learning Center?
July of 2022.
And who hired you at Tylertown?
Sabrina Carter.
And that's the same Ms. Carter that testified here earlier this week, is that right?
Correct.
And did you go through an interview process?
I did.
Tell the jury a little bit about your training to have that job at Tylertown.
So I had some online training where I had to obtain certificates. I had very little hands-on training. One of the hands-on trainings I did receive is to quickly lay the child back down so they could get their full nap. So yeah, that's about it.
What was your first assignment at Tylertown?
Assistant teacher in the 1-year-old room.
And did you ultimately go from assistant teacher to teacher in the 1-year-old room?
Yes, sir.
And how did you get that promotion from assistant to teacher?
So the lead teacher ended up putting her 2 weeks in. So once she left, I was up in that position.
Okay. Tell the jury a little bit about what the duties are for a teacher in the 1-year-old room at Tylertown Learning Center.
So the duties of a head teacher would be to make sure you have a lesson plan every week. Also, make sure there's regular diaper changes. They go outside twice a day, or we did foyer play when it was cold or hot. We also were responsible for nap, feeding, giving them their meals, and playtime as well, and reading books.
And what were your work hours at Tylertown?
I believe it was 7:30 to 4:30.
Do you remember what you were paid?
I was paid $10.50 an hour.
During your entire time of working at Tylertown, you remained in that 1-year-old room?
Yes, sir.
And just so it's clear to me, you began working there when?
July of 2022.
And then you were terminated on or about January 10 of 23, is that right?
Yes, sir.
So how many months is that? How long were you there?
7 months.
Let's talk about Olivia Hyde. That's what we're here about this week. When was your first interaction with Olivia Hyde?
My first interaction was that Thursday or Friday before, when Nicole was transitioning her and another child into my room.
And tell the jury a little bit about the transition of the children from the infant room to the 1-year-old room. How is that accomplished?
So what happens during transition time is they bring the children to the room, and they're basically trying to get the children to get used to me. So the transition when they come into the room is a little bit easier on the child, and then a little bit easier on me, so that we're used to each other.
What's the difference in the routine in the infant room versus the 1-year-old room where you were assigned?
The infant room, they have nap time anytime they want. They have, I think, like, certain babies probably have a schedule to when they need to be fed. But I feel like they would definitely eat more than we would in the 1-year-old room. And I mean, they would have free play like we would, but they were also allowed to have their pacifiers, and they had rockers in there. So it was a little bit easier to get the children to sleep.
In your mind, what was the significance of the infants and the 1-year-olds having access to their pacifier?
The significance was it was kind of a soothing thing to them, so it was easier for them to soothe themselves and to go to sleep.
And that was in the infant room, correct?
Correct.
Also in the infant room were there rocking chairs?
Yes, sir.
And what was the purpose of the rocking chair in the infant room?
I feel like a lot of babies need to be rocked to sleep. So, I mean, I know Willow, when she was a baby, we would rock her to sleep. So I feel like that's a really good thing to have, just to soothe the baby, get the baby down, get them ready to go to sleep.
You were telling the jury about Olivia's transition from the infant room to what I'm going to call the toddler room, the 1-year-old room. And that began the week before?
Yes, sir.
The week before January the 9th?
Yes, sir.
Okay. What did you observe about how Olivia Hyde was developmentally as she was making that transition?
I observed that Olivia was a little bit wobbly when standing. As you notice in the video, she was walking, but she's a little bit wobbly when she's standing sometimes. Also, if you realized in the video, she was falling out of her chair. So I feel like there was an issue with sitting up in the chair.
Ms. Fuson, let's talk about Monday, January the 9th, 2023. That's the day of the events that bring us here to court this week. Let's start by doing a little background. What was a typical day like in the one-year-old room when you worked there?
So a typical day was I came in at 7:30 and some kids would be there already, but some kids would be dropped off after 7:30 and the deadline for drop off was 9 o'clock. So basically they would come in, we would do breakfast, and then after that, I believe I would check diapers. And then after we checked diapers, we would either go outside or go on the foyer. After that, we would come back in the room and I believe we would do some free play. And then at 10:30 is when we got lunch. So once we got lunch, I would sit all the kids at the table, most of the time put the bib on them, and I would pass out the lunch to the children and they would eat lunch. After that, I would typically put the cots out. And in the video, you don't see that I'm letting them pick out the cots, but typically I would let them pick out their cots on where they wanted to sleep. So we would do nap time. I would go on my lunch for an hour during nap time. And then after I came back, they would typically still be down, but sometimes they would be up depending on which time I went to lunch. So when they got up, we would do diaper changes, of course. And then we would have a snack at 2 o'clock. After snack, we would go outside or go in the foyer for some motor play. And then after that, we come inside for some free play, lesson plans, art, stuff like that. And then after that, it would be pickup time. Parents would start picking up probably around 4:30, sometimes earlier, like early as 3:30.
Now, on January the 9th, 2023, were you the only teacher assigned to the toddler room?
Yes, sir.
And how long had you been on your own in the toddler room?
Basically, ever since Alyssa left, I was given people from time to time, but it would never be a permanent thing.
Okay, well, let's talk about that. You mentioned that Alyssa left the employment of Tylertown when?
Probably 2 weeks later, but it might have been a little bit later. But I feel like it was the end of July, and then she put her 2 weeks in, so it had to have been at the beginning of August.
What do you remember about your interaction with Olivia on that first day?
I remember having Olivia was having a hard time sitting up in the chair, and I remember she was having a hard time going out for naps. She didn't want to go to sleep.
Let's back up just a little bit. What do you remember about the drop-off that morning?
The drop-off was completely normal. On the 10th or on the 9th?
On the 9th.
On the 9th, yeah. The drop-off was completely normal.
Yeah, we're talking about Olivia's first day in the toddler room. So tell me again, what's your recollection of the drop-off procedure that morning?
My recollection was that she seemed, to me, she seemed like a happy baby at drop-off on the 9th.
And do you remember if her mother dropped her off at the room?
She did.
And what do you remember about the handoff between mom and you?
I remember getting her blanket, and she may have came in with a jacket too, and then getting her bag. And then mom said bye to Olivia, and then we just went on about our day.
And when you went on about the day, I assumed you served breakfast at some point in time?
Correct. That was at 8 o'clock.
And how did the breakfast time go on that Monday?
Breakfast time, she was having difficulty sitting up in the chair. I was pulling her up quickly because I didn't want her to fall on the floor.
And given your routine in the toddler room, when did you all do lunch?
That was at 10:30.
10:30 in the morning. And when did you do nap time?
Nap time typically started at 12.
And this is her first day in the toddler room, correct?
Yes, sir.
And when it got to be around noontime for nap time, what were your observations about how Olivia was doing at that time?
I feel like she was having a really hard time going to sleep. I feel like it would have been easier for her to go to sleep if she had her pacifier.
So what happened at nap time?
What happened at nap time is you see me laying her back down on the cot. I was not aggravated. It was not intentional. It was, the injuries were definitely by accident, just the bruises. And I was not slamming her. I was laying her back down.
But let's talk about the training that you received as to how to interact with children at nap time. What were you told about how you were to handle children at nap time?
I was told to lay them back down quickly so they could get their full nap.
And who gave you that training?
Alyssa.
And was this some big structured training program of some sort?
No, it was just hands-on training.
Okay. And how many, did she ever demonstrate to you how you were supposed to place the child back down?
I don't believe so, but she might have.
Okay. We've seen the video here several times this week. What do you think about how that video looks in terms of you placing or putting Olivia Hyde back down on the cot?
I can say that it does look a little rough, but I was not being intentional with being rough with her. The reason why I slid her down was to make sure she didn't hit her head on the plastic piece, and I made sure of that. Also, there is not a plastic piece under the mesh. It's just mesh.
Well, the jury will get a chance to see the cot. When you were first putting Olivia down for her nap, how did she appear?
She appeared to be upset and not wanting to lay down for nap.
Okay. Was she restless at all?
Yes.
Again, we've seen the video. In the moment when you were putting her back down on the cot, did you think that you were being rough in the moment?
I did not.
And then what was your reaction when you got to see the video?
I thought it had looked rough.
Okay. Now, on January the 10th, Sabrina Carter called you to her office, is that right?
Yes, sir.
And what was that all about when she summoned you to her office?
Basically, she just called me to her office to let me know that that Olivia had came into daycare with bruises on her arms, and that I feel like she said she found the video by then, because that was about 10:30. So yeah, so she had found the video by then, showed me the video, and I was like, yeah, that does look a little rough.
So this is Tuesday, January the 10th, is that right?
Correct.
And did Olivia return to school on that Tuesday morning?
Correct.
What is your recollection of the drop-off on the morning, Tuesday morning, the 10th of January?
So when Olivia was dropped off, I believe she was handed over the gate. And I remember her picking up a book, looking at the book, and waving to her mom bye.
Let's talk a little bit more about Monday, January the 9th at nap time. You were the only teacher in the room, is that right?
Correct.
And how many children were you taking care of on that nap time?
I was taking care of 6 children by myself.
And what sort of duties were you performing when you were trying to get all 6 of the kids down for their nap?
I was working on getting them down to sleep. A lot of them went down to sleep easy. And then I was also working on daily sheets as well while they were napping. I would write down the times that they fell asleep and then the times they woke up.
What was your state of mind around nap time on Monday, January 9th?
I was completely happy-go-lucky.
Were you angry?
Absolutely not.
Were you frustrated
No.
about anything?
No, sir.
Was there anything going on in your life outside of work that was troubling you?
No, sir.
Now, you can see on the video you putting her down on the cot. And does she eventually go to sleep?
Correct.
And how long did she nap?
I think I got her up like an hour and a half, so I feel like she napped about an hour and a half, maybe an hour and 45.
And what's the procedure in the toddler room? Do the children just wake up naturally, or do you wake them up? What is the typical protocol?
Typically, they wake up naturally, but if by 2 o'clock they're not woken up, we should wake them up.
Okay. What are they doing after 2 p.m.?
They are having snack.
Describe for the jury how did Olivia appear to you when she woke up on that Monday?
Olivia appeared to me to be normal. She was playing as normal, walking around a little bit as normal. She didn't seem fussy at all. She just seemed happy-go-lucky.
What sort of activities did you do with Olivia and the other children after nap time was over?
After nap time, I think that day we did foyer play because it was really cold outside because it was January. And then after that, we would do a lesson plan, maybe an arts and craft because we did that once a week. And then we would do some free play, and then it'd be time for pickup.
Okay. And what time is pickup generally?
So the latest they can pick up is 6. So they can come basically any time of day until 6.
And was Olivia picked up by her mom that day?
Yes, she was.
And what do you remember about the handoff between you and Mrs. Hyde?
I remember letting her know that there was trouble at nap time.
And how did you put that to her? How did you tell her that?
I just told her that Olivia had trouble at nap time.
We were also talking about January the 10th. Is that correct?
Yes, sir.
That's the morning that you were confronted by Sabrina Carter. Is that right?
Yes, sir.
And as a result of that confrontation by Sabrina, you were fired. Is that right?
Yes, sir.
And you were terminated effective January 10th of 2023.
Yes, sir.
Did there come a point in time after you were terminated that you wrote a letter to Sabrina Carter at Tylertown?
I did.
And do you remember when you did that?
That had to have been like a week after.
And what motivated you to write a letter to Sabrina?
I just wanted to apologize what transpired, and I wanted to let her know that I would never purposely hurt a child. And I also wanted to let her know that I was sorry that they were going through that investigation.
And you said that you put in the letter that you were sorry about what had transpired. And what did you mean by that?
I was just sorry that an investigation had started and what had transpired from what had happened.
Now, Ms. Fuson, you realize that you're under oath here today.
Yes.
And I want to ask you a couple of what I think are important questions on your oath today. On January the 9th, 2023, at nap time, were you trying to hurt Olivia Hyde?
No.
Were you trying to intentionally hurt Olivia Hyde?
No, sir.
Would you ever intentionally hurt a child?
No, sir.
And I think you've told us there was nothing going on in your life that day that would have had you troubled or out of sorts or anything like that.
No, sir.
Those are my questions.
State may cross-examine.
Good morning, ma'am.
Good morning.
You said that you have a niece named Willow, is that correct?
Yes, sir.
Okay. And you saw the video earlier?
Yes, sir.
Yesterday, this week. Let me ask you this. Would you want someone to handle Willow the way that you handled Olivia?
No, I would not.
Why is that?
Because I love Willow. She's literally like my child.
And you wouldn't handle someone that you loved in the way that you handled Olivia, correct?
I wouldn't handle any child that way like intentionally. That was not intentionally.
You're saying you handled her the way we saw in the video by accident?
I handled her the way that I was trained to handle her.
You said you weren't frustrated that day. Is that what you said?
Yes, I was not frustrated.
So when you're not frustrated, you grab 13-month-old children by the arm and shove them into a chair?
It was not shoving into a chair, it was pushing up the chair. And the reason why I pushed her chair up to the table is so she didn't slip down and fall under the table. I didn't want her to get hurt.
I'm going to play some of these clips again just so we can. So she slipped down right there, correct? She's crying.
Correct.
And do you agree that that was rough right there?
I mean, it does look a little rough. I will agree with that, but I wasn't intentionally being rough with her.
You keep saying intentionally. I mean, you're obviously intending to grab her by the arms and intending to shove her back into the chair. What do you mean by you didn't intend to? I don't understand what you mean by that.
I wasn't intentionally trying to hurt the child.
But you did, didn't you?
I feel like the bruises could have been done by me, but I do not believe that she has a skull fracture.
Okay, we'll get to that later. But you said the bruises could have been done by you. The bruises were done by you, really not.
It's a possibility.
Are you saying that someone else caused the bruises? Is that what you're saying?
I am not saying that. I'm just saying that it's a possibility.
Do you recall speaking with Agent Jonathan McGowan of the TBI?
Yes, sir.
Okay. Do you recall saying that you would never hurt a child?
Yes, sir.
That's not true, is it?
It is true. I would never hurt a child.
You did hurt a child, though, didn't you?
The bruises might have been done by me, but the skull fracture was definitely not done by me.
You did hurt a child, though, didn't you?
The bruises could have been done by me, but
It's bruising hurting a child.
yes.
And you said the skull fracture wasn't done by you.
No.
Called it a skull fracture, correct?
I mean, it's suspicious of a skull fracture. It was never diagnosed as a skull fracture.
So this is her first day with you, is that right?
Yes, sir.
Let's watch this close. Do you agree that she doesn't look ready to go to sleep right now? Is that accurate?
Yes, sir.
I agree. There you're saying you pushed her back to make sure her head wouldn't hit the plastic, right?
Yes, sir.
I would agree with you, you did on that one. Do you agree that you still handled her roughly right there?
Yes, I do agree with that.
See how close her head is to the edge of that cot?
She is close, but I made sure she did not hit her head.
Let's keep watching. She's not ready to go to sleep, correct?
Yes, sir.
Now, this next one coming up is the one I want you to watch. I know it happens fast because you push her down so hard, but watch where her head strikes. It was right at the edge of the plastic, wasn't it?
No, it wasn't. I made sure that she did not hit her
Let's
head.
watch it again. We can watch it as many times as we need to.
It was under.
Let's watch it again.
Objection. Showing of it. It's been asked and answered at this point.
Doesn't appear to be asked and answered, Ms. Older.
I'll move on, Your Honor.
Standing the objection.
Can I have the cot, please? So I believe you said that this is
Yeah, because I had heard you say yesterday that there was plastic under the mesh, and I thought you meant like the whole mesh.
Deputy Will.
That is a plastic piece.
Under the mesh, correct?
Correct. I just thought you meant the whole mesh, you know?
Do you recall when you were speaking to Agent McGowan saying that it looked rough, but Olivia was fighting against you so hard? Do you recall saying that?
I do recall that.
Your testimony is that a 13-month-old child was fighting against you so hard.
I feel like that is not true. I feel like I felt intimidated at the time. So I feel like she was popping up, but she wasn't like forcefully doing it, if that makes sense.
You were intimidated. Who were you intimidated
By the TBI officers.
So you told him a lie, said that she was fighting against you because you were scared of him? Is that what your testimony is?
Characterizes her testimony.
Your objection is,
My objection is his question mischaracterizes her testimony.
restate your question, please.
You said it wasn't true, is what you said, right? That would be a lie, correct? If it's not true, the alternative is that it's a lie. So you told the
This is cross-examination.
you told the TBI agent a lie because you were scared. Is that what your testimony is?
Yes.
Why were you scared?
I was scared because I was worried how far the case would go. And I know that was wrong. I shouldn't have done that. And I realize that now. I realize my faults.
You were scared how far the case would go because you knew what you had done, correct?
No. I know that she did not hit her head.
You called it on direct, you called it laying her back down. Is that what you still want to call it today after watching the video?
Yes, sir.
And you also said at some point 2 or 3 times that it was an accident. You still stand by that?
Yes, sir.
I believe you said she was restless while you were laying her back down. Is that what you said?
Yes, sir.
Would you have continued to keep slamming her head down the way you did if she had continued to pop back up?
I feel like after that 8th time, I probably would have picked her up and held her, because it was so many times and it wasn't working.
Because you had slammed her down so many times, but it finally did work. You finally knocked her out, correct?
It was not slamming, and I did not knock her out because afterwards she did not show symptoms of a concussion or being knocked out.
But you have experience in this toddler room a little bit. Do 1-year-olds normally go from fussy and fighting like that to immediately motionless? Is that normal?
She was motionless because she went to sleep. It wasn't because I knocked her out.
Okay. You must have a special ability to put someone to sleep instantly. Is that what you're telling people?
I mean, I guess, but I just know that she was not knocked out. She did not have a concussion because she did not show signs of it.
You said she eventually goes to sleep
Yes, sir.
after you slammed her head into the plastic edge of
It was not slamming in the head, did not hit the plastic piece.
Then you testified that after you woke Olivia up, she seemed normal. Is that what you said?
Yes, sir.
But earlier you said that you also testified that you were overwhelmed and busy with 6 kids in there as well, correct?
I don't believe I said I was overwhelmed.
You said you were busy and alone with 6 kids. Is that what you said?
I don't remember saying that.
Would have been hard to focus on Olivia alone, and wouldn't that be accurate to say? You had 6 other kids.
I mean, sometimes it is difficult, but if all of them are, laying down and napping, then it's not difficult.
When on direct, when Mr. Striens was asking you about the 10th of January, you said that when Mrs. Macy Hyde dropped Olivia off, all you recall was her getting a book and waving goodbye to her mom. Is that what you said?
Yes, sir.
So are you saying that when Macy Hyde testified the other day that Olivia was scared, are you saying that Mrs. Hyde is lying? Is that what you're saying?
Yes, sir.
And do you recall telling Agent McGowan during your interview that you wrote the letter because your father told you to write the letter?
I did say that, but it was also a part of me wanting to do it as well. It was just a suggestion from my dad.
Was that a lie as well, or was that true?
No, that was true. Mhm.
I could have 1 moment, please, Your Honor.
All right.
Just wanted to, one more question, ma'am.
Yes, sir.
Other than the part about Olivia fighting you, were there any other lies that you told to the TBI?
No, sir, there was not.
Thank you, Your Honor. I have no further questions.
Redirect, Mr. Strange.
Ms. Fuson, let's talk about the TBI interview. When you woke up the morning of that interview, did you expect to be contacted by the Tennessee Bureau of Investigation?
No, sir.
And you were, what, 22 years old at the time?
Correct, because it was 2023.
And you were contacted by phone, is that right?
Correct.
And what do you remember about the phone conversation between you and the agent?
They basically said that they needed to meet with me to get my side of the story.
Did you call your parents before you decided to meet with the TBI?
No, I should have definitely called Dad, but I didn't.
And then you met with the TBI agent voluntarily, is that right?
Correct.
And there were 2 agents, is that correct?
Correct.
And they interviewed you in Clarksville?
Correct.
Remember how long that interview was?
I feel like it was like 15, 20 minutes.
And were you truthful with the TBI agents?
I was, other than the part where Olivia was fighting me.
Okay. And what about Olivia fighting back at you? What was wrong or incorrect about that statement?
She was like popping up, but the part that was incorrect is that she was fighting hard.
Okay.
She was fighting me, but she wasn't fighting me hard. She was at a normal,
So that was just really an unfortunate statement that you made to the TBI.
Correct.
Meaning that you characterize it improperly.
Correct.
Were you trying to lie and mislead the TBI?
I wasn't trying to at the moment, but at the moment, that's what I recalled happened. But as I have went over the incident in my head multiple times, I realized that's not what happened. So at the time, I thought that was what happened. But then as I went over it over the years, I realized, it wasn't.
Okay. But I mean, you knew Sabrina Carter and Tylertown had a video of it.
Correct.
And as you talked to them, you knew that they would have access to that video. Is that right?
Correct.
So it sort of was what it was on January the 9th.
Correct.
Those are my questions.
Holder, anything further?
FBI agents came to meet you where you asked them to come meet you, is that correct?
Yeah, I told them it was okay to come to Crunch to meet me. I think that was a bad idea, though.
They didn't surprise you, though. They called you and asked.
No, absolutely not. They definitely called me and asked me where it would be a good time to meet.
And then you just clarified on redirect, you said Olivia was fighting, she just wasn't fighting hard. Is that what you're saying?
Correct.
Okay. Thank you.
Strange. Thank you. You may step down. Strange, you may call your next witness. What?
Coach.
You may. On or off? Record. All right, the defense is rested, so the state has the opportunity now to put on rebuttal proof. So does the state wish to put on rebuttal proof? Dr. Lakin, if you'll come forward, please.
Good morning, Dr. Lakin. Thank you for coming back again today. Were you present yesterday for the testimony of Dr. Pena, Dr. Henkes, and Dr. Matches?
I was.
Okay, let's start with Dr. Pena. I believe he testified first. Was there anything in his testimony that you disagreed with that you wanted to clarify for the jury today?
Yes, there are a few things that I disagree with Dr. Pena. I'm sorry.
Ladies and gentlemen, if you'll step across the hallway, please. Turn his microphone on, or just come to the podium if you will.
Dealing with expert witnesses, she does not agree at a baseline with any of the defense experts. So to call her, to give her an opportunity just to rehash her direct examination and comment on the testimony of the expert, the defense experts, is not really true rebuttal proof. I would ask the court to hear this testimony out of the presence of the jury so we can determine if it's truly rebuttal proof or if it's just she doesn't like their opinion and they want another crack at educating the jury about their theory.
Mr. Holder? Well, the whole purpose of allowing, under the rule, an expert witness to remain in the courtroom and to observe the testimony of another expert is to allow them to address the testimony of that expert and to differentiate what their opinion is from that of the expert. While Mr. Stryans is correct that, just stating her own opinion would be different, but my understanding is that she's been called to differentiate her testimony from that of the other, or to show the reasons why she disagrees, the same way that the defense expert was allowed to sit in on her testimony and then to testify, especially the last witness we had, who testified at length about why she was wrong in her opinion. So I think that she's entitled to, but we'll allow her to testify ask her questions outside the presence of the jury, and we'll go from there.
Maybe a little more specific then, Dr. Lake, and I apologize for that. So you heard Dr. Pena's testimony specifically about, I guess, concussions and diagnosing concussions. What did he say that you specifically disagreed with about concussions?
So, excuse me, when Dr. Pena was describing concussions in young children, he made it a point to say how difficult it was to diagnose concussions in young children. Because symptoms, just as we were actually in agreement when I testified, I also said it is very difficult to diagnose symptoms of concussions in young children. But yet he insisted that Olivia did not have a concussion because she didn't show any symptoms of concussion. So he's basically saying the same thing. He's saying she doesn't have a concussion because she shows no symptoms of concussions, but children can't be, or it's difficult to diagnose concussions in very young children because they don't show symptoms of concussion. And where we have a difference in opinion is that I believe she showed a very significant symptom of a concussion because on the last head strike, she becomes motionless. And that is not the way children fall asleep.
Thank you. And I also want to ask you about, Dr. Pena testified that he agreed that the bruising showed signs of maltreatment, but that he called it a wormian bone, did not show signs of maltreatment. Did you disagree with the way he was separating the two incidents? Did you disagree with that?
Yes. So when we are, as child abuse physicians, and we're both child abuse physicians, when we are evaluating children for maltreatment, you look at the entirety of the presentation. So what I mean by that is exactly what he did as an expert, which is he looked at the history, he looked at the physical exam findings. He didn't have the benefit of examining the child in person at the time, nor did I. You look at the radiological studies, and then you put everything together to determine whether there was maltreatment or not. The idea of separating out an injury to try to divide up things in terms of what may or may not have happened is not the way we do our assessments. And so Olivia had a skull fracture. We had video evidence of the incident, which we rarely do, but we had video evidence of the incident which would support the injuries that we see. That's kind of how we come to our conclusion whether or not non-accidental trauma has occurred. Do the injuries that we find support the history that's being given? And in this case, were the injuries that we found were the injuries that were found and the video that we observed support the injuries that we see? And they did.
Thank you, ma'am. I'm going to move on to Dr. Hinkes's testimony now. She testified at one point that it was rare to see a fontanelle close. She called it early. In your experience, what is a normal time period for a fontanelle to close?
That was very interesting to me coming from a PhD as opposed to a medical physician, because again, I practiced pediatrics. I practiced general pediatrics for 3 years, and then continue in pediatrics, evaluating young children, infants, every day, all day long. Fontanelles close, there's a range, probably around 7.5 to 8 months, and then late closure would be probably after 18 months, and the average is about 12 months. As a matter of fact, we start monitoring if it doesn't close by 12 months, and then if it closes before 7 months, that's actually a medical condition called craniosynostosis. And obviously, if it was, as she put it, too early, then we would be talking about Olivia having a diagnosis of craniosynostosis, which she does not.
Thank you, ma'am. I'm going to move to Dr. Matches's testimony now. There was several points I wanted to address with you regarding his testimony. He used the term bregma a lot. What was he referencing with, what is a bregma, and what was he referencing with that? So
bregma basically designates where the bones come together, the frontal bone, the two parietal bones. It's what we call the anterior fontanelle in an infant when it hasn't completely closed together. So it is basically where they all come together. But it sounds fancy.
And then on one of his images that he used in his procedure, the virtual autopsy procedure, the one where I think he said he dissected the skull and inverted it and put a bunch of energy into it to enhance it. And it created this faint line that was much fainter than the darker line. Did you have an opinion as to what that faint line is?
I do. And I actually mentioned it before because obviously bones are not completely smooth. And we're talking about basically almost computer animation with what we're doing with, our studies now, all this digitized things. And just like with anything else with animation, you can get what we call background noise. So the idea is that you're taking multiple, just thousands of pictures in different directions, all sorts of directions. So anything that it's a computer that is not completely, in the same plane may create some noise in the background. But things that are real, so and definite, like a fracture, a broken bone, that's the way we read them. That's where the defect is.
Is that why it appeared so dark on the scan?
Correct. And that's why you do have a radiologist read. 3D reconstruction is a form of a virtual autopsy. It's actually the images that they use for 3D reconstruction, which we do for live patients. It's the same. It's those images are used and interpolated into their so-called virtual autopsy. He mentioned that that's like an actual like proprietary thing now. And the hospital doesn't use that on live patients. Excuse me, and I don't even think a lot of medical examiners use that yet because it's so expensive. The software is so expensive. But anyway, so the 3D images basically do the same thing. And our radiologist looked at it, saw the defect, and said he didn't have the benefit of seeing the video or given the history. It just said child with head trauma, suspected child abuse. That's all the information he has. And so the radiologist, part of their support, because it's a clinical diagnosis, he was looking for soft tissue swelling to confirm. But there wasn't any soft tissue swelling, and the reason why there wasn't any soft tissue swelling is because it was weeks afterwards, or 10 days afterwards. And so the radiologist not having the benefit of that information, that term is going to be put in there, but the fracture is real. The defect is real. You can see it. You can see it on our 3D reconstruction. You can see it on Dr. Match's virtual autopsy. There was a difference in the parallel line to the sagittal suture and what he claims is the third side, making it what he calls triangular. But the other distinction I have with that whole presentation, they keep calling it a Wormian bone, and a Wormian bone is in the suture. And actually what they're alleging is this is an anterior fontanelle Wormian bone, which is extremely rare, and it's in the fontanelle. And what they're trying to say is that this supposed triangular piece of bone, it's not in the fontanelle. It's beside the sagittal suture, so that it's not a Wormian bone, and it's not an anterior Wormian bone.
That's what I didn't want to get into another over-complex discussion of the Wormian bone, but I did want to ask you that, which I think you just covered. You said it was not intrasutural, and is that what you just explained?
Yes.
Okay. And were you surprised that Dr. Matches didn't have any examples to show us of Wormian bones that looked like Olivia's?
Correct, and that's why I showed a picture of what an anterior Wormian bone looks like. They're fragments, they're not like, they're even described in the literature as usually being kind of round.
Were you able to find any examples at all of a Wormian bone that looked what we see in Olivia's scan?
No.
That'd be my questions.
Brian, do you wish to cross-examine on those issues? I'm sorry? All right. I'll hear you.
Your Honor, respectfully, this is not rebuttal evidence. Taking each of the doctors that she's challenging one at a time, Dr. Pena, she agrees with Pena that it's difficult to diagnose concussions in children. Dr. Pena spoke yesterday about the children being nonverbal, can't ask them questions that could help diagnose a concussion. So my view of it is they put her on in direct. We put and she was subject to cross-examination. We called our experts in direct. They were subject to cross-examination by the state. The state already gets 2 arguments. This is sort of like a third argument to the jury, giving her the opportunity to be a surrogate for them, to argue things that they want to get into the record, her commentary on the findings of our experts. She was asked on direct examination about the Wormian bone. She's already given the jury her fulsome opinion about it was not a Wormian bone. So I don't know why it would be rebuttal to call her back at this point and have her comment on that. With Dr. Hinkes, that is a completely ancillary issue about the fontanelle, whether it was closing or not closing. That is not an issue for the jury to determine in this case. To have her gratuitously comment on that under the guise of rebuttal proof, I don't believe is appropriate. She, for some reason, doesn't really like the word bregma, but it has nothing to do with the jury's consideration of the expert proof in this case. It's, in terms of why it's not a Wormian bone and why there is no swelling, she testified about that in her direct examination. She told the jury that due to the passage of time, 10 days, she didn't expect to find any bruising or swelling. It's already in the record, so I don't think there is any proper purpose to call her in rebuttal, and I think it would be unfairly prejudicial.
Holder, Mr. Moore?
I already stated the purpose of Dr. Lakin staying in the courtroom during their testimony was to be able to rebut the proof that they provided. The point of rebuttal is to controvert evidence of an adverse party. That is what Dr. Lakin is doing. The fact that Mr. Striance doesn't like what she's saying does not mean that it should not be allowed, and the state believes that Dr. Lakin should be allowed to testify in rebuttal, Your Honor.
Well, it's this court's opinion that the jury's understanding of the conflicting expert testimony is one of the main issues in this case, and that we have a total of, by my recollection, 4 expert witnesses who are testifying about the same issues. The fact that the state has the burden of proof and they put their expert on, allowing the defense experts to sit in on that, and then the defense experts were allowed to come in and testify at length about why they disagreed with Dr. Lakin's evaluation. And the state has the right to put on rebuttal proof. The defense's argument is it's not rebuttal proof for her to get up and say why she disagrees with their opinion. But at the time she testified, she had not heard their opinion. So by giving her the opportunity to listen to their opinions and their findings, then she is now, in this court's opinion, entitled to come forward and testify as to the reasons why she believes that their testimony was not accurate or was in fact inaccurate. And I would simply point out that there are provisions under the rules of criminal procedure that allow the court some flexibility in reordering the expert witness proof. It can be done by agreement of the parties so that they hear one expert after the other, but that's usually requires to be done with the consent of the parties. But the notes on that rule make it clear that the purpose of that rule is designed to assist jurors in understanding conflicting expert testimony by providing considerable flexibility in scheduling and in the mode of the testimony. So the rules are clear that it is within this court's discretion as to how that's to be presented, and it's this court's opinion, having heard Dr. Lakin's testimony, that her testimony does constitute rebuttal testimony, and therefore the objection of the defendant is overruled.
Judge, we disclosed to the state pretty detailed expert reports for all of our experts. Dr. Lakin had the benefit of those expert reports before she testified. I think a review of her direct examination, when she was called by the state, I guess it was yesterday, would reflect that she had the benefit of those reports, and she tailored her direct testimony to address the things that the defense experts put in their report. I just want to try to make a record on
And that's fine. I still believe that it does not, in this court's opinion, prevent the state from offering rebuttal proof because the jury has heard from 4 different experts, 3 for the defense, 1 for the state, and the state has the final say in their presentation of the proof, and I'm going to allow that. I didn't like it when I was a defense lawyer, that the state always had the right to open and close everything, and I'm sure that's not, most defense lawyers would like to have the final say and not have the state have the final say, but that is the rule. So I have made my findings that her testimony does constitute rebuttal proof, and I will allow that to take place. We are ready for the jury. While the jury's come in, is this your final witness? Is there any rebuttal? You have any? Have you all had an opportunity to review the final charge? Any issues with that? All right, then we're ready to print the final charge. So, all right. Hold on just a second.
Yes, sir.
All right, counsel, approach the bench. The initial instructions I gave you, and I'm going to repeat them over and over again, is that you should not worry about what I do outside of your presence. When I consider an objection, my ruling is made based on what I interpret to be the law. And you should not try to figure out what it was that was objected to or why, how I've ruled. You should just understand that to the best of my ability, I'm applying the law as I understand it to this case, and I make rulings on objections, and that should not infer to you that I hold an opinion one way or the other about this case. So with that, Mr. Holt, yes. I think we need to address it on the records. Well, we're just going to do it on the record instead, so.
Thank you for letting me address the court on this
It's all right.
issue. Until I saw the note from the juror, and just so the record's complete, could we read that note into the
Holder,
our trial jurors? And the question that the trial juror asks is, did Dr. Larkin have the opportunity to see the internal view of the CAT scan? Question mark. Prior to seeing this note, I really had no interest in trying to have Dr. Matches listen in to this rebuttal testimony. But this is a very serious case, and this question goes right to the heart of Dr. Matches' direct testimony yesterday. I would like to have the opportunity to just take a minute to see if I can get him to join virtually and hear the answer to that question by Dr. Lakin.
Mr. Holder?
That question is about the 3D rendering that was turned upside down and why the one line was so dark and what that Dr. Lakin testified was noise. That's basically what this juror is asking in the state's opinion. I don't know what changed with me asking it or the juror asking it. We would ask to be allowed to proceed as is. I mean, it was asked by me of Dr.
He's
Lakin
saying he
today.
asked in our jury out hearing that question, and that there was no, problem is that when we're in a trial, and I understand, and I agree, this is a very serious case, but we're in the third day of the trial. The fact that you didn't choose to have Dr. Mathis sit in on her testimony, and now suddenly we've got a second decision to make, is a trial tactic that I'm not sure would justify a delay in this proceeding to simply obtain this Dr. Mathis.
Practice of letting the jurors ask questions. And as I said, I would not have thought of really needing to have Dr. Matches listen to any of this rebuttal proof until, consistent with this court's practice, one of the jurors sent a question that I think I would like to have him listen to. This is not any sort of a trial maneuver on my part. I'm just trying to deal with these issues as I'm confronted with them. And as the court knows, everything that I do will be analyzed at some later time, depending on the outcome of the trial. So I need to be mindful of what my obligations are and mindful that the record is as protected as I can possibly make it.
All right, well, we're at 10:15 in the morning. I'm going to give Mr. Stryans until 10:30. We'll take our mid-morning break for him to see if he can round up his expert. If he can do so, then we'll allow that expert to sit in on the testimony he will not be on camera, but he'll be allowed to do it, to listen in on it. And when we resume at 10:30, with or without Dr. Mathis, we'll proceed on with this trial. So We're in recess for 15 minutes. I'm going to advise the jury of the fact that they're on break. Mr. Lyons, anything to report? Well, the question, and I think he has just now come into the waiting room. We will allow him to come into the hearing, but he will be on mute. Hand that question up here to me, if you will, Mr. Holder. All right. Dr. Lakin, the jury has asked a question. I'm going to ask it outside of their presence. The question is, did Dr. Lakin, they call you Larkin, but Dr. Lakin have the opportunity to see the internal view of the CAT scan?
Yes, I did.
Okay. So with that being the case, I'm not sure how that would justify having the defense's expert on serve rebuttal, but we'll deal with that in a moment. So then bring the jury in. All right, ladies and gentlemen, in your absence, I considered there was a question that was handed to me by the bailiff that one of you has asked, and I'm going to go ahead and ask it of this witness. Question that was submitted by the jury was, did Dr. Lakin have the opportunity to see the internal view of the CAT scan? So I will ask you that question. Did you have that opportunity?
Yes, I did.
All right. Then at this point, I have, outside of your presence, I think I've already touched on the fact that I have considered an objection, and I have ruled on that objection according to what I believe the law would provide. And now the state, Mr. Holder, through the state, is going to go ahead and question this witness on what we call the rebuttal proof.
Thank you. Good morning, Dr. Lakin. Again, thank you for being here. Mm-hmm. Let's go ahead and start there, since that was the question that the juror asked. You were present for Dr. Matchis's testimony yesterday.
Yes, I was.
Okay. And you said that you did view the internal image of the CAT scan. I believe he called it the part of the virtual autopsy process.
Yes, I did.
And what was your opinion? Was it different as to what he testified to?
I'm sorry.
I'm sorry, no,
Yeah.
Please go ahead. Yes, ma'am, I'm sorry, I kind of spoke over myself there. You said that you did see the internal scan, and what did you disagree with that he testified to?
So Dr. Matchis was alleging that that area that we're discussing was not a fracture and was actually a triangular piece of bone, which was what he considers to be a Wormian bone, and he made references to the bregma. The bregma is also the same thing as the anterior fontanelle in infants that hasn't closed yet, so it's the same thing. Once you don't have an anterior fontanelle, the area where the bones come together is called the bregma. It's nothing different, nothing fancy. Where we differ in terms of the fracture versus the Wormian bones by definition are in the suture, intrasutural. And we all agreed that Wormian bones in the anterior fontanelle are extremely rare, highly unusual location. But more importantly, the way I view the 3D reconstruction is what we do on our live patients when the CT scan is done. That's actually part of the information that they use as part of the virtual autopsy, because it's basically multiple pictures and multiple dimensions that the computer puts together to put all of these things together. You can get a lot of background noise, and I think I mentioned that before, because these are computer pictures and the bones in your skull, all of your bones are not completely 100% smooth. So when he talked about the computers aggregating all of these photos together, then you can get some background noise and you can see little ridges and things that are in the bone. That's not the same thing. And if you look at the appearance of where our radiologist at Vanderbilt called a fracture, suspicious for fracture, and what I believe to be a fracture is a very, very dark line in the 3D reconstruction. But that area that they're trying to say is the other side of it to make the three, he described it as a triangular piece of bone, is actually doesn't even have the same appearance as where the fracture is.
Let me stop you right there. I'm sorry to interrupt. Is that why it's so much lighter in color than the dark line
Right.
of the fracture?
Yeah. And so the other issue that I have with his testimony is that, again, a Wormian bone is intrasutural, and I showed an example of what an anterior fontanelle Wormian bone would look like, which is rounded. And it's this area that he claims is a triangular Wormian bone is outside. It's to the left of the sagittal suture. It's not even in the suture. It's not in the anterior fontanelle.
And were you able to find any examples of Wormian bones that would have looked like Olivia's scan looked?
No.
Dr. Matches didn't provide any examples either.
Yeah.
Let's jump to Dr. Pena. I believe he testified about concussions, and he said that based on what he saw in the video, he didn't believe Olivia sustained a concussion. What is your opinion about that testimony?
So Dr. Pena and I are both child abuse physicians, and in terms of this particular part of his testimony, that goes into your general pediatric training, and we both agreed. We both said it is very difficult to diagnose concussions in infants. They don't show or they can't describe their symptoms. But I thought it was really interesting because he then goes on to say, but he does not believe that she had a concussion, but he also says it's very difficult to diagnose a concussion. And I believed that she did have a concussion because she did have a very significant symptom when she is fighting to go to sleep and going back and forth and going back and forth, and then suddenly becomes motionless. And to me, that is a very significant symptom in a child of 13 months old that is awake and crying and then goes motionless. And so I disagreed with him, very much so, as far as whether or not Olivia suffered a concussion.
Also, with Dr. Pena's testimony, he was differentiating. He believed that the bruising was a cause of maltreatment, he said. But he said, I believe that the scan of the CT scan of the skull did not show any maltreatment, and he was separating the two. What is your opinion about the way he separates the two?
So as child abuse physicians, we have to incorporate everything. We don't separate out injuries. So much of our assessments are done if the history supports the injuries that we see. In this particular case, we had an opportunity not only to have a history of what may have happened, we actually had a video to see what happened. So we were able to put together a history also to see from a video the actual incident. It's not in our, the way we assess for maltreatment. We're not going to divide things up and say, this is or this isn't. As a matter of fact, it's something that kind of is the foundation of how you make your assessment on the injuries that you see. You have to incorporate the whole picture.
Thank you, ma'am. Lastly, just briefly, we'll touch on Dr. Hinkes. She testified on about a fontanelle, which is, for lack of a better term, is that the soft spot that people
Yes.
say? She said that it was rare to see one almost closed with Olivia at 13 months. What is your opinion about that?
So that one is, I completely disagree. And as a practicing physician, Dr. Hinkes is a PhD. She is not a practicing physician. I've seen thousands and thousands of infants and toddlers like every day, all day long. That is actually the average of when your fontanelle closes. It usually closes around 7.5. We see the closure happen maybe 7.5 to 8 months, starting to begin up until, around 14 or 15 months, and the average is around 12 months of age. As a matter of fact, if it is closing too early, then you would get a diagnosis of craniosynostosis, which Olivia did not have. So the average is around 12 months, and I completely disagree that that was too early.
Thank you, ma'am. I have no further questions at this time.
Mr. Irons, you may cross-examine.
Good morning.
The CT scan showed this linear lucency, is that right?
That's correct.
But there was no intracranial abnormality, is that right?
That's correct.
That means that there, in this case, there was no traumatic brain injury sustained by Olivia Hyde, correct?
Well, a concussion is actually considered a mild traumatic brain injury.
But there was no intracranial abnormality, correct?
The very definition of a concussion is to have a negative CT scan but have neurological findings.
This morning, you're saying there was a concussion.
Correct.
Your report says, and your diagnosis was that there was a probable concussion.
Correct.
Okay. So it's moved from a probable concussion yesterday, and now in rebuttal, it's a concussion.
Well, I'm saying that what I saw on the video was that she had a very distinct change in her neurological status. So I do use probable because I didn't get to physically examine her, and I can only rely on what I see in the video.
And
So I can keep it as a probable concussion.
it's a probable concussion that you're diagnosing looking at a video, is that right?
I made no diagnoses. That is my opinion as to what I'm seeing.
Yeah,
So
but
I'm
it's-
not making a diagnosis.
Okay. Well, you've offered an opinion about a probable concussion.
Correct.
And you're basing it on what you saw on that January 9, 2023 video, is
That's
that
correct.
right?
Yes,
Where, in your opinion, she loses consciousness.
correct.
Okay. But you also know that Olivia Hyde's parents never noticed any symptoms of a concussion.
And I disagree with you because there is documentation that they reported increased irritability right after the event.
They did not report nausea, correct?
You do not have to have all of the listed symptoms, and a 13-month-old is not going to be able to tell the parent that she's sick at her stomach.
They did not notice any vomiting.
Correct.
Right. They didn't comment that they felt like their daughter was not acting normal.
Again, irritability would be a change in her behavior.
Yeah, and irritability at one moment in time is what you're talking about, is that right?
It was at her visit with the PCP right after the event.
Right.
Not right after the event, it was actually on the 13th,
Right.
where it's documented that they reported increased irritability.
Right. Now, at that Hopkinsville visit, they gave her a complete clean bill of health, is that right?
So they gave her a physical exam and checked her hematocrit, which is not the same thing.
Not
I have.
the primary care physician, which is a Vanderbilt outlet, is that right?
It is, and it's a nurse practitioner.
Okay. And you have no questions about their competency
Nope.
because you are part of the Vanderbilt University Medical Center process, is that right?
I'm part of Vanderbilt, yes. I'm a Vanderbilt physician.
This is what they said when they saw her on the 13th. She was there for blood work and a physical exam, correct?
Correct?
What they noticed was that they noticed bruising, which was resolving, is that right?
Correct.
The rest of the visit was completely unremarkable, is that correct?
That's correct.
That she had a painless range of motion in her extremities,
Yes.
did not appear to be in any distress whatsoever, correct?
Correct.
All of her lab results were normal, is that right?
Correct.
And that's in Hopkinsville with the primary care physician on January the 13th, correct?
It's with the primary care provider, yes.
And the parents never reported that she was not eating,
No.
never reported that she was having bouts of incessant crying.
I'd have to look at that note. I don't even remember that as a specific question.
Well, you didn't read any suggestion of her having incessant crying in any report, did you?
I don't recall seeing that, no. I also don't recall seeing it as a question. I don't know that a question would be asked, is your child incessantly crying?
But you're basing it on a pretty non-specific symptom of irritability.
No, I'm not basing it on a non-specific. You asked me if she had any symptoms, and I said she had the symptom of irritability. What I'm basing it on is what I saw in the video, with a crying toddler that keeps getting up, and all of a sudden, on the very last strike, she becomes motionless.
The parents never reported that Olivia would fall asleep, rouse, and immediately fall back asleep. Nothing like that.
No.
So the only objective symptom that you've identified to label this as a probable concussion is what you think you see on the video, and then a general irritability.
It's not what I think I see on the video, it's what I saw on the video.
You said that the anterior, to have a wormian bone in the anterior fontanelle would be rare and unusual.
Correct.
You're not saying that they don't occur, are you?
Correct. I actually showed an example of one.
And I think you generally agree with Dr. Pena, is that right? In terms of the difficulty in diagnosing a concussion?
Yes.
Mainly because children of that age don't speak.
Correct.
You can't ask them straightforward questions about how are you feeling? Do you have a headache? Are you in pain? Things like that.
Correct.
So what is it that you differ with Dr. Pena about?
Dr. Pena does not believe that she suffered a concussion or that she had a fracture.
And you've had your opinion based on what you saw, is that right?
That's correct.
And you looked at all of the material that was produced in discovery in this case.
Correct.
Just like Dr. Pena and Dr. Hinkes and Dr. Matches. Is that
Correct.
right?
Mm-hmm.
I assume that you will assume good faith on the part of your colleagues when they look at the same information that you looked at. Is that right?
What do you mean by good faith?
That they're like you, they're trying to be as objective as they can be.
I think objectivity can be influenced.
Okay. So in your profession, I guess it's not like the legal profession where I assume good faith on the part of my colleagues and adversaries in this case. Are you saying that in the medical profession that you don't start off at a baseline of your colleagues acting in good faith?
I would like to assume that people are acting in good faith. In this particular situation, we have 3 individuals that are all employed by the same organization.
Okay, well, you and your colleagues are employed by the Vanderbilt University Medical Center.
We are.
Is there something sinister to be employed, a group of people by the same entity?
Well, we are an entity that are employed by a very large hospital system that sees patients for medical care.
You're not saying that the Vanderbilt University Medical Center and that hospital system is perfect
Absolutely
or
not.
blameless. I mean, just a couple of years ago, CMS was out there. Is that right?
I'm not aware. I've only been at Vanderbilt since 22.
Since 22. Okay, you never heard about that.
No.
You never heard, what is CMS?
I don't know what the term stands for, but they do a lot of the in-hospital regulatory.
It's the federal government, correct?
No, it's an agency. I guess it's a federal
Yeah,
agency.
an agency of the federal government that were out there investigating the Vanderbilt University Medical Center. Is that right?
What was that for? I don't know.
You worked there and you didn't hear anything about it?
No.
I have one moment.
Right.
Just one other thing on the Wormian bone. When, in a case like this, where an issue of a Wormian bone comes up, doesn't it have some real radiological significance and importance?
It absolutely does, which is another reason why if our radiologist had thought it was a Wormian bone, they would have said concerning for a Wormian bone or consider a Wormian bone. And it did not have the appearance of a Wormian bone.
What they said was linear lucency,
Correct.
suspicious for fracture.
Correct.
But isn't part of the importance of the presence of a Wormian bone, perceived presence of a Wormian bone in a case like this, that it can be mistaken for a fracture?
It can be mistaken for a fracture.
Right? And if it's mistaken for a fracture, then somebody could end up in a courtroom like this.
That's correct.
Those are my questions.
Mr. Holder, you redirect?
Mr. Stryance was asking you about, excuse me, the January 13th visit in Hopkinsville. At that time, Mr. and Mrs. Hyde nor the treating nurse practitioner, they had no reason to suspect a head injury at that time, did they?
Correct.
So they wouldn't have done any kind of examination to check for possible concussion, is that right?
That's correct.
Thank you, ma'am.
Ryan's, anything else?
This event happened on January the 9th, is that right?
Yes.
And which I think was a Monday. And if my math is correct, Olivia is taken to Hopkinsville to the Vanderbilt Pediatric Clinic on Friday the 13th.
Correct.
You've dealt with small children professionally and I assume personally.
Yes.
And in bathing small children, I think they're bathed every day, where parents are washing their heads, washing their bodies.
Mm-hmm.
In your experience, isn't that often a way that a parent finds something on the scalp of a child at bath time?
It can be, but it doesn't always happen that way.
I know that, but in your experience, you've received cases where parents maybe have a child in daycare, they're bathing the child, they're washing the child's head, and they see a knot on the head. They see a bluish discoloration on the head or the temple area. Is that right?
Yes, it can be, yes.
Thank you.
Anything further, Mr. Holder? Thank you, doctor. You may step down and have a seat. Do you have any other rebuttal witnesses? Ladies and gentlemen, if you'll step across the hallway, please. All right, the state has rested their case. Mr. Stryance, that you had requested that a Dr. Mathis be brought in, and I allowed that. Are you intending to try to offer any additional proof? Well, then that answers that question. So then we are ready to move to closing arguments. Both sides have concluded the proof. Mr. Stryance has previously renewed his motion for judgment of acquittal on the record, and I have denied that on the same basis that I found earlier, that there was sufficient evidence, taken state's evidence in the light most favorable, that there is sufficient evidence that the jury could reach a verdict. So I am ready to bring the jury in and allow the parties to. All right, ladies and gentlemen, you have heard all of the proof that you are going to receive in this case. Both sides have rested their proof, and the next step in the process will be for the attorneys to make their closing arguments. So the state will open with their closing argument. The defense can then offer their closing, and then the state has the right to make a final closing argument. Mr. Holder?
Ladies and gentlemen, I just want to thank you for your time and attention this week. I know it's been a long week, and I know everybody's ready to get back home to their family, but very much appreciate it, and it's an important service in our community. And I promise I won't keep you too much longer. I know you've heard enough from us this week as well. Just briefly wanted to go back over the law briefly. I know the judge is going to go over that in more detail in a little while, but I just want to touch on it briefly, like we discussed in jury selection. The statute. The injury for is described as cut, abrasion, bruise, burn, disfigurement, or physical pain. Any person who knowingly, other than by accidental means, treats a child under 18 years of age in such a manner as to inflict injury. That defines use. We already defined the injury, and knowingly, we've defined that as well in the past. As far as aggravated, like I said, what differentiates that is the age of the child, under age 8 years of old, 8 years, and it includes a serious bodily injury. And like it says on the slide, it includes, but is not limited to, a fracture of any bone, a concussion, severe bruising, and the judge is also going to instruct you that it includes what's called protracted unconsciousness. Protracted just means for a length of time, not like if you were to immediately fall asleep. Now, don't be confused. The state doesn't have to prove that Olivia suffered all of these. We don't have to prove that she suffered a fracture, she suffered severe bruising, she suffered a concussion, she suffered unconsciousness. We just have to prove one of those. The indictment does not say she suffered severe bruising, she suffered a concussion, she suffered a fracture. It just says she suffered serious bodily injury. Some of you agree that she suffered a fracture, but some of you don't agree that she didn't have severe bruising. That's okay, as long as all of you agree that she suffered some of this or one of these. That constitutes serious bodily injury. Now, let's talk about the facts that are not in dispute, okay? What's not in dispute is that whatever injuries you believe Olivia suffered that day, they occurred on January 9th, 2023 at Tylertown Learning Center in Montgomery County, Tennessee. And whatever injuries she suffered, they were suffered at the hands of Ms. Sarah Fuson, the defendant. Those facts are not in dispute. Let's talk about the bruising. You saw those bruises. You heard from Dr. Lakin, and you heard how those bruises were inflicted. You saw the video, you saw the photos of the bruises. Both Dr. Pena and Dr. Matches, the defense doctors, agreed that these bruises were inflicted by Ms. Fuson. Dr. Matches, on cross-exam, when I was questioning him, he stated that these bruises were not a severe injury, but he did state that these were severe bruises. Imagine the force necessary to leave an imprint of the clothing on Olivia's body. Imagine how hard you would have to squeeze somebody's arm to leave an imprint of clothing on their body and for it to remain days later. I submit to you that that's severe bruising. Let's talk about the concussion. You heard from Dr. Lakin. She believed Olivia most likely suffered a concussion based upon what she saw in the video, and that her head was struck repeatedly down over and over, and on the final time into the hard plastic edge that rendered her motionless. Unfortunately, we didn't have anybody to report any symptoms immediately following this incident for the next 4 to 5 hours. All we have is video, which shows Olivia sitting, crawling, stumbling around a little bit. And when they went to examine her at the Hopkinsville, which would have been 4 days later, nobody knew that she suffered a possible concussion. That wasn't until days later when law enforcement recommended to DCS that they contact the parents and have her evaluated further based upon what they saw in the video. Mr. and Ms. Hyde did state that she was irritable, showing signs of irritability, but they had no reason to suspect that she had suffered head trauma. They weren't looking for anything. They could have missed something. Now let's talk about the unconsciousness prong. You heard from Dr. Lakin. She stated that a 1-year-old does not go from fussy and squirming around to totally motionless in an instant. And you heard that from Dr. Lakin, but use your own common sense. Have you, let alone a 1-year-old, does anybody just fall asleep in an instant? The defense experts disagreed with this, but like I said, just trust your own eyes. Watch the video. I'm going to play it again here in a moment when we talk about the fracture, but watch the video as many times as you need to back there. Rewind it. Watch her go from squirming and pushing herself up to totally motionless after her head is slammed the final time. And I used the word slammed. The defense experts didn't use the word slammed. Ms. Fuson didn't use the word slammed. But that's okay. It doesn't matter what word I use or what word they use. You define what it was. You're the finders of fact in this case. Ms. Fuson stated she wasn't ready for a nap that's why she was forcing her down over and over. And then she said she finally fell asleep. The state submits to you, she was knocked unconscious. She didn't fall asleep. And I think the video proves that. Let's move on to the fracture. That's the big point of contention this week. The defense made a point of mentioning this week that law enforcement was the first to mention the word fracture, but that's simply not true. The first person to mention fracture was the radiologist at Vanderbilt, who said that this was a suspicious for fracture. They didn't say it's suspicious for a Wormian bone. They said it's suspicious for fracture. At the time the radiologist made this diagnosis, they had not seen the video. They hadn't seen photos. They hadn't seen the cot. They didn't know what was even alleged. They just knew suspected abuse. He looks at the scan, looks like a suspicious fracture, so that's what he notes. Dr. Lakin says it is a fracture. The three different defense experts call it a Wormian bone. Now, what is true is nobody used the term Wormian bone in this case until the defense brought up the term Wormian bone. You saw the examples of Wormian bones that Dr. Lakin provided. None of them look like the scan of Olivia's head. None. The defense experts had no examples of Wormian bones that look like Olivia's scan. It was a straight line, and it was not connected within the sutures of her skull. Dr. Matchis wants you to believe that with his virtual autopsy process, by inverting the skull and removing the top of the skull and putting all this intensity into it, I believe he called it, that he could make some sort of connection to make it a triangular shaped bone. That's simply not true. You heard Dr. Lakin explain that, and that's why the straight line was so much darker than the other portion, which was just a natural bump on her skull. The skulls are not smooth, as you heard from Dr. Lakin. Dr. Pena, he reluctantly admitted on cross-exam that if Olivia's head had hit the hard plastic edge, that it could have caused a fracture in the location we saw on the scan. He just said that her head didn't hit the hard plastic edge. And again, I disagree with that, and I'm going to play the video again one more time for you to see. And I ask you, again, to watch it in the back as many times as you need to, rewind it if you need to. Watch, I'm going to stay quiet, but watch the final time that she is slammed down. Watch where her head hits. And then when you're back there, get that cot. Feel the edge of that cot and see where her head hit. Like I said, you could decide where her head hit for yourself. As I said, you're the finders of fact. Watch that in the back as many times as you need to. Grab the cot, feel the cot. Do what you need to do with that. But you decide where her head hit, not me, not Dr. Lakin, not Dr. Matches. You do. Now, Dr. Lakin is also the only doctor who had all of the information in this case. The radiologist, all he had was the scan. He didn't have the cot, he didn't have the video. Dr. Hinkes, Dr. Matches, and Dr. Pena, they had the scans and they had the video and the photos. None of them ever saw that cot in person. They never laid a hand on that cot. They can't see that there's a hard plastic edge underneath the mesh at the end of that cot. I'm not saying they're lying. They may have thought her head only hit the mesh because they never inspected it. I'm asking you to inspect it, feel where the plastic is, watch the video, see where her head hit. She's also the only doctor who testified here today that's totally unbiased. She hasn't been compensated for her testimony. She has no dog in this hunt. She's simply doing her job. Her job is to protect children, and that's what she's doing. Now, when the defendant was testifying, you heard her say she wouldn't want anyone to handle her niece Willow the way she handled Olivia. And I asked her why. She said because she loved her niece. Well, Macy and Thomas Hyde love Olivia, and she did not deserve to be treated that way. And the state is here to ask you to hold her accountable for the way she treated Olivia and the injuries she caused to her. And I'm going to ask you to find her guilty of aggravated. And thank you.
Mr. Hines, you may address the jury.
I also want to thank you for your time and attention this week. I know it can be sort of a hardship to be separated from your families and having to make arrangements for work and things like that. I just want you to know that I recognize that this is a hard job to come down here and sit as a juror in a case like this, and we do appreciate your work. You all have probably heard of the telephone game. It begins with a group of people either standing in a line or sitting in a circle, and one person whispers something in the ear of the person right next to them. Then that person attempts to repeat what they heard or what they thought they heard to that next person in line, and this continues one after the other until the end. And then in the telephone game, the last person tells the group what he or she heard. And the whole point of that exercise is the incredible difference between what the first person said and the last person heard. Yesterday morning in this courtroom, we all learned, and I was surprised to learn it, that the telephone game seems to be alive and well and being played in the world of criminal investigations. And let me tell you what I mean by that. I'd ask you to search your memory, and if you took notes, to look at your notes about the testimony that you heard first thing yesterday morning, which seemed to be, to me, the day started that it would be sort of mundane, Wednesday, rainy day testimony. But there was testimony from Caleb Sherman with the Department of Children's Services, Alan Pendarvis from the Clarksville Police Department, and TBI case agent Jonathan McGowan. They were all advanced as witnesses, one after the other. And I just sort of want to set the scene for you because I think this is important. On January the 19th, 2023, that was the day that Olivia was seen at the Monroe Carroll Children's Hospital in Nashville for the CT scan. On that day, and try to remember the testimony, the TBI case agent McGowan spoke with Detective Alan Pendarvis from the Clarksville Police Department. They had a telephone conversation. The Clarksville detective, Mr. Pendarvis, tells the TBI agent, Mr. McGowan, that he received a case referral in relation to Olivia Hyde. Then Pendarvis recommends to Caleb Sherman that Olivia be medically evaluated at Monroe Carroll. And presumably, Mr. Sherman calls the Hydes and she ends up at Monroe Carroll. Later, Detective Pendarvis calls Sherman, and Sherman said that he was told, I'm going to emphasize he was told, that a hairline fracture, quote unquote, a hairline fracture was found during Olivia's CT scan at Monroe Carroll. And ladies and gentlemen, that phantom skull fracture, that non-diagnosis or diagnosis, however you look at it, was born. What was seen at Monroe Carroll as a linear lucency that was suspicious for fracture, as a result of that telephone tag they were playing on January the 19th, it became a hairline fracture. And the significance of that is it formed and shaped the opinion of the investigators in this case. And every law enforcement document that was produced from January the 19th, 2023, when this phantom diagnosis was not communicated properly between the police officers and the investigators, that became what was perceived by them to be a fracture. And between January the 19th of 2023 and the date that the indictment was returned in this case in April, that's what they thought happened. And I'm sure when Mr. McGowan, since that's what he was told, appeared before the Montgomery County Grand Jury and presented his short summary of the case, I'm sure that that was on his lips, that there was a hairline skull fracture. And the group of citizens that returned the indictment that brings us here to court today were likely told that very explosive phrase, hairline skull fracture, being sustained by a 1-year-old. You may remember the testimony of Caleb Sherman, sort of a small irony in all of this. I asked him who had told him about this hairline fracture. He's no longer with DCS, based on his testimony, and he said he couldn't remember. So to me, that revelation that we heard Wednesday morning about how this whole thing got started was more significant than the pitched battle that we saw yesterday and carried over until this morning between these earnest experts. I think it became a key to understanding how a linear lucency suspicious for fracture became a skull fracture and set all of this week in motion. I want to talk a little bit about the medical proof. I know you're probably up to here with the medical proof, but just a few things that I thought were significant that I hope you will consider when you go back there and deliberate. According to the state's opening closing argument, they want you to go back there and just watch the video over and over and over again. But I'd ask you to go back there and consider the testimony as well and the proof that you heard. We're starting with the premise of a CT scan that showed a linear lucency, but significantly, ladies and gentlemen, I'll ask you to talk about it today when you're deliberating, no intracranial abnormality. And I sort of had to pry it out of Dr. Lakin, but I think she grudgingly agreed that that means that in this case, there was no traumatic brain injury to Olivia Hyde. There was no damage to Olivia's brain caused by the accident or whatever you're seeing on January 9th or other trauma. Dr. Matches testified, and you heard him yesterday. He wanted to be here, but due to the government shutdown, he was not able to get here. Dr. Matches had conducted a virtual autopsy with some very advanced CT review of the raw CT data and a 3D reconstruction. He testified to you yesterday that the virtual autopsy revealed no skull fracture. And looking at all the hospital records, that opinion is supported. There was no residual swelling. There was no sign of healing. There were no breaks. There was no depression of a bone into Olivia's skull. There was no bleeding. What Dr. Matches told you, based on the advanced techniques that he uses, he found an accessory suture consistent with a wormian bone, a normal extra piece of bone. And I asked Dr. Lakin this morning about the radiological, if I'm pronouncing that correctly, significance of this whole wormian bone in the calculus of this type of a case. And she agreed with me that it's important because a fracture can be confused with a wormian bone. Let me say that again, and she acknowledged that. And Dr. Lakin doesn't really like to acknowledge facts that she finds inconvenient. The significance of this presence of the wormian bone is that it could undermine and should undermine the state's prosecution of this case because it can give a false positive of a fracture. On January 19th, 2023, I just have a few more comments about the medical proof that you heard. There was, when Olivia went to Monroe Carroll Children's Hospital, there was a full trauma series of x-rays, a full blood workup, and a CT scan. And when you get back there and talk about these records, there was an x-ray that was taken of her at Monroe Carroll in addition to the CT scan. The x-ray offered no evidence of fracture or other bone abnormalities. I think you heard that this week. Both the soft tissues and bone density, which were evaluated by the skeletal survey that you also heard about this week, were within normal limits. Images of the spine, abdomen, arms, and legs revealed no extensive bruising. You heard Dr. Matches acknowledge that the actions of Sarah Fuson did cause the bruising, but he said that they were not consistent with severe injury and not consistent with assault. That those marks resulted from rough but non-assaultive handling. He also said that there was no evidence of any high energy trauma, skull fracture, or brain injury. We also learned in an evaluation of all the medical proof that all the vitals analyzed in the blood test that was done at Vanderbilt were within reference range and normal. I'd like to talk about that Tylertown video, the troubling video that you're going to have to confront and deal with in trying to arrive at a fair and just result in this case. I'd ask you, as rough as that looked to you, and please discuss this, ask yourselves when you get back there, does anyone really believe that 22-year-old Sarah Fuson, who has an associate's degree, this is one of her first jobs as a young adult, knowingly and intentionally set about to inflict on Olivia on the first day of Olivia's school in the toddler room? I think that's an important question, and it's a hard question that you all will have to consider and answer. Or is it more likely that Sarah was hustling in the room, multitasking in the room? She's got 6 children that she's taking care of, and that she acted recklessly. At the end of the arguments, the judge is going to read you what's known as the jury charge, the law that the judge is going to ask you to consider in evaluating the proof in this case. And I would ask you to take a look look at it all. It's all important. There's not one thing that's more important than the other. But I would ask you to take a look at, in my copy would be page 7, there's a definition of the term recklessly. And I think the judge will tell you in a few minutes, and I'm not going to read the whole thing to you, but I think the judge will tell you that recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial risk. That's not the whole instruction, but I would ask you, in evaluating what the appropriate mental state for Sarah Fuson on January the 9th, 2023, when she was dealing with those children in the room, what was her mental state? I've already suggested to you it was not knowing, it was not intentional, that I'm suggesting that it was a reckless mental state. Obviously, that's all for you to decide. When we began this on Tuesday morning, I think the last thing that I told you in my opening statements still sort of holds, and I still think it's apt to your consideration of this case. You have a lot of jobs and duties as jurors, but what I told you on Tuesday morning, I think still remains. It's not your job to go back in the jury room today and solve this case as to whether you think that Olivia Hyde sustained a skull fracture. If you get back there and you can't decide if she, based on all of the evidence, the defense proof, the state's proof, then the state has not done its job in convincing you beyond a reasonable doubt of the guilt of Sarah Fuson. And if you find yourself in that position, it would be your duty to acquit Sarah Fuson. Now, there are many charges that the judge is going to read to you in the jury instructions. There are lesser included offenses. And when I was directing your attention to the concept of recklessness, I would ask you to consider those offenses that deal with a mental state of recklessness. And I appreciate your time and attention this morning, and I thank you for your service on this jury.
Mr. Moore?
Members of the jury, I get to go last because the state has the burden of proof. You've heard that several times, but I hope not to be too long in summing this up, because the sooner I sit down, the sooner Judge Wolf will read the final jury instructions, and the sooner you'll be able to deliberate on this case. And the sooner we will know what the truth is by your verdict. And the truth the state submits is that this defendant is guilty of and aggravated just based on everything that you have seen and heard. Like Mr. Triance, like Colonel Holder, not going to read the instructions that the judge is going to give you, but one thing I wanted to say, and this is in response to Mr. Striance, the way I heard it is like, oh, well, just pick and choose, go down, forget about intentional or knowing. Well, the judge is going to tell you, I submit, that the charge, the element is knowing other than by accidental means. Even the defense experts told you this wasn't an accident. She knew what she was doing. And she was getting paid for it. Whether it was $10, 10 cents, $100, or what was it Dr. Matches gets, $550 an hour. She had a duty to that child. And the first duty is to do no harm. Jury instructions. One of the things that Judge Wolf's going to tell you, it's what we lawyers call sequential jury deliberation. You don't pick and choose. You go down the list. You start with the highest charge. And if you believe the state has carried its burden of proof, which I submit to you we have, the verdict should be guilty. That's the oath you've sworn. Do justice. Only if all 12 of you who go back into the deliberation room for some reason find that she is not guilty of aggravated abuse do you move down. Don't just jump down. I understand why Mr. Ryans would want you to, but that's not the way the law works. And the business about this being a telephone game, because who started this in the first place? Ms. Fuson. But who started the reporting? Sabrina Carter. That's her duty under the law, and she followed it to a T. She began the investigation. She communicated. DCS worker, detective from Clarksville, on to Agent McGowan. Okay, so which one of them should have dropped the ball? Which one of them should have not made a call? Should have just let this go by the wayside? They communicated. The case was investigated. You've heard the proof. You've seen it. And that blue cot laying over there, you can take it back and you can feel it. Talked about believability of witnesses. Those same rules of how did the person impress you? Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? So on and so on. Common sense, how we judge people in our everyday lives. And Ms. Fuson judged by those same rules because she'd taken the stand and testified. Members of the jury, if there ever was someone who testified from the stand and had no concept of accepting responsibility for what she did, you heard it this morning. And of all the unmitigated gall to sit there and say Olivia Hyde's mother is a liar, I will submit there are two sets of good parents in this courtroom. Fuson's and Olivia's. But they're not the ones on trial. They didn't do this. Sarah Jo Fuson is responsible like any adult. That is the purpose of the criminal law. That all people are accountable for their actions regardless of their station in life or anything else. Accountability. And we heard many times about how fortunate that this was not worse. So we had the virtual moment, that last eighth slam took place, and Olivia Hyde never moved again. Another video. Watch and see it. What did she tell you? That was her lunch break. You are the judges of the credibility, the believability of the witnesses. Do you believe that some witnesses did not tell the truth, or were motivated by some other reason, be it accused of serious crime. And this isn't serious. Probably, at least hopefully, never see something like this again. But it happened. It happened, and Sarah Jo Fuson is the one who did it. All this I submit on behalf of the state of Tennessee is not reckless accident, not a rough handling. What you call what you saw and what you've heard the last few days, aggravated, that's what it's called. What do you do about it? I respectfully submit what you do about it based upon the state having proven this case beyond a reasonable doubt is to come into this courtroom and return a verdict of guilty of the charged offense. Thank you very much. I submit the case to your consideration.
All right, ladies and gentlemen, you will now receive your copy of the final charge. Ladies and gentlemen, if you'll follow along with me. The defendant, Sarah Jo Fuson, is charged in the indictment in count 1 with aggravated, necessarily included within a charge of aggravated or the lesser included offenses of aggravated assault, reckless aggravated assault, and reckless endangerment. In count 2 in the indictment, the defendant is charged with necessarily included within a charge of so the lesser included offenses of assault and reckless endangerment. The defendant pleads not guilty to each and every offense embraced in the indictment. The evidence and arguments in this case have been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The law presumes that the defendant is innocent of the charges against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all of the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case, and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Montgomery County, Tennessee, and that it was committed before the finding and returning of the presentment in this case. The burden is upon the state to prove by a preponderance of the evidence that this offense was committed in Montgomery County, Tennessee. Proof by a preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced and consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Montgomery County, Tennessee, then you must return a verdict of not guilty. Excuse me. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the alleged crime for which she is charged. In considering the identity of a person, the jury may take into consideration all of the facts and circumstances in the case. The court further charges you that if you are satisfied from the whole proof in the case, beyond a reasonable doubt, that the defendant committed the crime charged against her, and you are satisfied beyond a reasonable doubt that she has been identified as the person who committed the crime charged, then it would be your duty to convict her. On the other hand, if you are not satisfied with the identity from the proof, or if you have a reasonable doubt as to whether she has been identified from the whole body of proof in the case, then you should return a verdict of not guilty. As heretofore stated, in count 1, the defendant is charged with the crime of aggravated. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the act of abuse resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. Serious bodily injury to the child means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, an organ or mental faculty, or a broken bone of a child who is 8 years of age or less. Serious bodily injury to a child includes, but is not limited to, second or third degree burns, a fracture of any bone, a concussion, subdural or subarachnoid bleeding, retinal hemorrhage, cerebral edema, brain contusion, injuries to the skin that involve severe bruising, or the likelihood of permanent or protracted disfigurement, including those sustained by whipping a child with objects. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct, when the person is aware of the nature of the conduct or that the circumstances exist. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct when it is the person's conscious objective or desire to engage in the conduct. If you find the defendant guilty of aggravated as charged in the indictment, you shall so state. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of aggravated, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. Were to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused a bodily injury to another, and 2, that the act resulted in serious bodily injury to another. Bodily injury, serious bodily injury, knowingly and intentionally have already been defined. If you find the defendant guilty of aggravated assault as the lesser included offense of aggravated, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of aggravated assault, you shall then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of reckless aggravated assault. Any person who commits the offense of reckless aggravated assault is guilty of a crime. Were we to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant recklessly caused bodily injury to another. 2, that the act resulted in serious bodily injury to another. Bodily injury and serious bodily injury have already been defined. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct, when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted knowingly or intentionally. Knowingly and intentionally have already been defined. If you find the defendant guilty of reckless aggravated assault as a lesser included offense of aggravated, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of the reckless aggravated assault, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense. Any person who commits the offense is guilty of a crime. For to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant knowingly, other than by accidental means, treated a child under 18 years of age in such a manner as to inflict an injury, and that the child, two, that the child was 8 years of age or less. Knowingly has already been defined. If you find the defendant guilty of a lesser included offense of aggravated, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant caused bodily injury to another. Two, that the defendant acted either intentionally, knowingly, or recklessly. Bodily injury, recklessly, and knowingly, and intentionally have already been defined. If you find the defendant guilty of assault as a lesser included offense of aggravated, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of assault, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of reckless endangerment. Any person who commits the offense of reckless endangerment upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury, and that the defendant acted recklessly. Serious bodily injury, recklessly, knowingly, and intentionally have already been defined. If you find the defendant guilty of reckless endangerment as a lesser included offense of aggravated, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of reckless endangerment, then you shall acquit the defendant of this offense and proceed to count 2. As heretofore stated, in count 2, the defendant is charged with the crime of. If you find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant knowingly, other than by accidental means, treated a child under 18 years of age in such a manner as to inflict injury. And two, that the child was 8 years of age or less. Knowingly has already been defined. If you find the defendant guilty is charged in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements, and the elements for assault have been set out in count 1. If you find the defendant guilty of assault as the lesser included offense, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of assault, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of reckless endangerment. Any person who commits the offense of reckless endangerment upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements, and those elements have been set out in count 1. If you find the defendant guilty of reckless endangerment as a lesser included offense, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of reckless endangerment, you shall acquit the defendant of this offense. During the trial, you heard expert testimony. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness. It is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background and training or experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all of the other evidence in the case. The defendant having testified in her own behalf, her credibility is determined by the same rules of credibility of other witnesses is determined. You will give her testimony such weight as you think it is entitled. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with your fellow jurors. During your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. The verdict must represent the considered judgment of each juror. To return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you will first select one of your members as the foreman or forelady who will preside over your deliberations. When you've reached a verdict, you will return with it to this courtroom and your foreman or forelady will announce it. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find her guilty. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to her guilt, then you must find the defendant not guilty. You will be provided with forms for all possible verdicts in this case. The jury will complete the appropriate verdict form and your foreperson will sign the appropriate verdict form. The crime charged in each count in the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all offenses charged. Your finding as to each crime charged must be stated in your verdict. In reaching your verdict, you shall first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, then you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or if you have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you have unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. If after your deliberations you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. Now, ladies and gentlemen, before you retire to begin your deliberations, I will select the two alternates, and that will be by randomly selecting the numbers. All right, if you'll escort them out through the hallway, please. Thank you, gentlemen. Ladies and gentlemen, the remaining jurors are our trial jury that will decide this case. We are now at the noon hour, so we're going to go ahead and instruct you to go ahead and before you begin your deliberations, let's go ahead and take a lunch hour. When you come back, before any discussions occur, before any consideration of the evidence occurs, make sure that all 12 people are present in the jury room, and you cannot discuss this case. If one of you is in the bathroom, stop all discussions. Don't do any discussions unless all 12 of you are in there at the same time. And if you need anything from us, let us know. If the exhibits, the hard exhibits, will go back with you to the jury room. If you need to, usually I know it was said you could watch the video as many times as you want to back there. We typically bring you back into the courtroom and watch it in here so that everyone can see those parts that you watch. And because they're on a thumb drive and a computer is necessary, it is more advantageous for us to have you come back in. So if you want to watch any of the videos again, just let the bailiffs know and we'll bring you back in and we'll play whatever portion you want. All right? So we will now allow the jury to retire, take their lunch hour until 1 o'clock, and then be back together in the assembly room down below, and we brought up together as a group to go into the jury room to begin your deliberations at 1 o'clock. All right, thank you. Our process here is usually to, even though there is a TV in the jury room, we have traditionally brought them in here to watch any sort of video. So Mr. Mr. Holder, if you'll get it ready to play, we will bring the jury in as soon as we are ready. All right, bring the jury in. All right, ladies and gentlemen, I've been handed a note that you have requested to rewatch the video footage of nap time, so we will play that for you. Excuse me. Ladies and gentlemen, if anyone indicates that you want to watch that again, all right, they've requested to watch it again, please. All right. Ladies and gentlemen, if you would like to retire to resume your deliberations, thank you. I'm sorry?
I wanted to put something on the record if I could.
All right.
The jury had a question, I think it was approximately 1:42 or so. We were notified that the jury had a question on version of the video. Brought them in about 1:45 and they watched that Zoom version of the video. Asked the court to consider on Tuesday morning or Tuesday, the first day of trial, there was a longer version of the video that was offered as evidence by the state, which shows a longer period of time than I don't know if they were interest motivated to want to see it because they were against trying, see it because they were trying to evaluate the testimony about concussion. I would request that they
Well, you're asking me to bring the jury back in and without their request, make them watch a different version than what they requested, is what I'm understanding.
realize it's unusual, but just in terms of
Would it not be reopening the proof to do that? One thing to allow a jury to ask a question or a jury to come in and say, we'd like to rewatch something. They specifically stated in their note, we would like to review the up-close video footage of nap time. And that was what they asked. So that's what they were shown. And so you're now asking that I bring them back in and I have them watch a longer version, which is not something they requested.
I just was concerned that they may focus on a version.
That is their prerogative to look at the evidence and to assign the weight that they think is appropriate. So I understand your position.
Yes,
and I am going to deny your request, but it's obviously on the record now, and I'm denying the request because the only reason they were brought back in and shown that version is that's the version that they specifically requested. So,
Yes, sir.
all right.
Thank you.
Then we'll stand adjourned. Anything else then before I recess?
sir.
All right, we'll be in recess again.
Okay, so the biggest thing I saw today, or the biggest thing I have seen throughout this case, is why didn't they get another scan like within the past 3 or 4 months? And I think I know the answer. I think the answer is that if it showed, calcification, that would signify that it was a fracture. And so if they see the calcification, it buries their client. So on the defense's side, they wouldn't want that. On the prosecution side, they might be saying kind of the same thing. What if it clearly is a wormian bone? Now, our case goes out the window. But in the interest of justice and fairness, wouldn't you want that? I mean, do you really want to send somebody to prison? And the charge, I think the minimum is 15 years for that charge number 1. Do you really want to send someone to prison when it may or may not be true? Now, count 2, I'm not sure. I didn't look up the minimum for count 2. But count 1 is the one that carries the most. I'm certain. And it's 15 to 60 years. So, do you really want to send somebody to prison for that if it's not true? At least that's my opinion. But, everybody wants to win. So, and then the other thing is when Sarah Fuson was on trial, was on the witness stand, and she she kept saying there was no concussion, there was no concussion, there was no concussion, because she didn't act that way. Well, you're not a medical professional and you don't know her, because you were only there, she's only been with you for a few hours. You do not know this person. So, how would she know? I think those comments were meant to steer the jury in a certain way, but I wouldn't have been steered that way. I would have thought, man, you sound like you think you know it all. At least that's my opinion. So, thank you guys for watching. Stay tuned for the verdict. That'll be out in a few. I'll see you